Hey everybody, it's Sean Henricksen here from the Sean Henricksen Law Firm. We help good people avoid the devastating consequences of criminal charges. Today, I want to talk a little bit more about speedy trials. You've got the right to a speedy trial, but do you really want a speedy trial or not? The Supreme Court has said that the longer between a crime allegedly having been occurred and the time that an actual trial occurs, the less reliable that trial is going to be. Despite that, there are a lot of attorneys, a lot of defense attorneys, who will delay a case as long as possible. And there are a lot of reasons for that too. One of the main things that happens is that the longer the time goes, the less or the more likely it is that some of the witnesses aren't going to be able to testify or no longer want to testify. And if there are certain witnesses that don't want to testify or are unable to testify, that could lead to a case being dismissed. There's also certain evidence that may not be available anymore also. So surveillance tape may have been available if the trial had been earlier on, but if everything is delayed, maybe that surveillance video has been recorded over or is no longer available. And so there are a lot of different things that can happen that can benefit a defendant if we just delay a case basically as long as possible. But despite that, I generally think that it's a better idea to push a case forward quicker. First off, I'm going to say that every case is different, and so some cases we may want to try and delay the case, but in most cases, I'm going to try and push a case forward as quickly as possible. And there are some reasons for this. So first off, while the case is pending, you're on bond, which means that if there are any conditions of bond, you have to keep following through with those conditions of bond. You may not be able to have contact with somebody. You may be on a breathalyzer or some other machine, and you may have to check in with pretrial services or your bail bondsman. And there's just the added stress of having this thing hanging over your head with no end in sight. And I find that a lot of my clients want the case to be over quicker rather than later. The other thing is that certain cases are going to ultimately get dismissed if we just push things and delay things. There's a small percentage of cases that are going to get dismissed and not go to trial, but most of them, even if we delay things, the state is still going to be ready to go to trial, and so we're still going to be at that point of going to trial. And when we do go to trial, everything, as the Supreme Court has said, the trial is going to be less reliable. Ultimately, if we're having a trial, we want to get to the truth of the matter. We don't want to have a trial where you've got witnesses that are testifying to something that didn't happen exactly the way it happened because their memory has faded or something like that. So we want you to have a fair trial. The other big thing that happens is that if we are delaying things, then we are waiving your right to a speedy trial. If we were to bring a motion later on for a motion to dismiss the case, and if it looks like the state has been on top of everything and been ready, and we are the ones that have been asking for resets and delays and everything, then the court's not very likely to grant us the motion to dismiss based on that speedy trial right. And there are cases where the state is the one that are dragging their feet. The state are the ones that are causing delays. And we want to push things forward, which means that the state is more likely to be asking for delays, which means that we're going to get cases dismissed for the state violating your right to a speedy trial. And so I think that that as far as the cases are getting dismissed, I think it's kind of a wash whether we push things forward or whether we delay things as much as possible. Again, we may vary our strategy depending on the facts of your specific case, but I think in general, it's better to push on so that we're not waiving that right to a speedy trial. And since we're not getting a lot more cases dismissed by delaying things, then really what I'm looking at is what's going to be the impact on my client. If they're having to just sit through this and go through the stress of having this charge continually hanging over their head, then let's just get that out of the way as quickly as we reasonably can. Obviously, I'm not suggesting that we take offers at the first setting or anything like that. I'm going to work up your case just as fully as I would if I were delaying everything for years and years. But I'm just going to do that sooner so that we can get to that proper resolution faster. And push the state so that they have to make a decision sooner rather than later, or they risk violating your right to a speedy trial, which is going to be another way that we can get your case dismissed. If you have any questions about your right to a speedy trial or why you would want to delay it versus pushing it forward quicker, feel free to give me a call. My phone number is 210-900-2806, and have a great day, everybody.